Corey Richens was convicted unanimously and beyond a reasonable doubt of attempting to murder Eric Richens, her husband, and the father of their 3 children. And then, having failed in her first effort of spending the next 17 days, not changing course, but doubling down, preparing to try again, and ultimately completing the act through the administration of poison. And for what? Money. All for pecuniary gain. A person convicted of committing that sequence of acts in that way and for that reason. While inside the courtroom, everyone involved in this process must be treated with respect. We cannot have any outward reactions inside the courtroom. If any of you feel overcome with emotion, frustration, anger, whatever, of any kind, please remember just to look down. Keep your hands folded in your lap. The court has considered the following information: the evidence, information, arguments, and recommendations provided by counsel on the record today, victim impact statements and other statements made on the record today regarding the appropriate sentence, and the pre-sentence investigation report as corrected on the record today, including the numerous statements attached to it. In addition, the court has considered each of the factors set forth in Utah Code 76-3-201 subsection 2B and has prioritized those factors as required by section 201-2C. Having considered the gravity and circumstances of the offenses for which Ms. Richens has been convicted, the number of victims, and available information regarding the history, character, and rehabilitative needs of the defendant, the court hereby orders that the sentences on counts 2 through 5 shall run consecutively to each other and to the sentence imposed on count 1. Moreover, the court exercises its discretion and chooses to impose no fines related to any sentence in this case. The court addresses the 5 counts on which Ms. Richens was convicted in reverse order. Ms. Richens, based on your conviction on count 5, third-degree felony forgery, the court hereby sentences you to an indeterminate prison term not to exceed 5 years. Based on your conviction on count 4, second-degree felony insurance fraud, the court hereby sentences you to an indeterminate prison term of not less than 1 and not more than 15 years. Based on your conviction on count 3, second-degree felony insurance fraud, the court hereby sentences you to an indeterminate prison term of not less than 1 and not more than 15 years. Based on your conviction on count 2, first-degree felony attempted aggravated murder, the court hereby sentences you to an indeterminate prison term of not less than 5 years, and that may be for life. Which brings us to the final issue, the appropriate sentence for count 1. Under Utah Code 76-3-207.7, there are only 2 options: an indeterminate prison term of not less than 25 years, and that may be for life, or life in prison without parole. And the law requires that the court consider each option. Under a sentence of 25 to life, and considering the effect of the 4 consecutive sentences, the time that Ms. Richens has spent in custody, and the current practices of the Board of Pardons and Parole, Ms. Richens would likely serve approximately 30 years in the Utah State Prison before receiving her first parole hearing. By that time, she would be 66 years old. Under a sentence of life in prison without parole, Ms. Richens would be in prison for the rest of her natural life, unless the Board of Pardons and Parole determines by clear and convincing evidence at some future point that she is permanently incapable of being a threat to the safety of society, at which time the board would have the authority to release her. Under either scenario, Ms. Richens will be incapacitated, meaning structurally prevented from harming anyone outside the Utah State prison system for at least the next 3 decades, and perhaps much longer. But the potential impact on the survivors of the tragedy created by Corey Richens, most importantly, Eric Richens' 3 sons, is more difficult to predict. On one hand, if the court sentences Ms. Richens to life without parole, one or more of those young men may come to resent that the court eliminated any opportunity they might have in the future, decades into the future, to express an opinion as adults with substantial life experience about whether their mother should, for example, be allowed to die with dignity. On the other hand, if the court sentences Ms. Richens to 25 to life, one or more of those young men may spend the next 30 years questioning why the court failed to protect them from the prospect of the person who murdered their father being released from prison at some time in the distant future, perhaps when they have families and children of their own. The court's contemplation of how those young men may come to feel about today's decision some 30 years from now comes from a place of genuine concern for them and humility regarding the court's inability to predict the future. Sitting here today, it is simply not possible for anyone, not even those young men, to know how their view of this case may evolve over the next several decades. My hope is that every person affected by Eric Richens' death will, over time, find their way to a state of peace. As for today, the court's duty is to make a decision, a weighty, long-lasting decision based on the best information available today. And the bottom line is this: Corey Richens was convicted unanimously and beyond a reasonable doubt of attempting to murder Eric Richens, her husband, and the father of their 3 children. And then, having failed in her first effort of spending the next 17 days not changing course, but doubling down, preparing to try again, and ultimately completing the act through the administration of poison. And for what? Money. All for pecuniary gain. A person convicted of committing that sequence of acts in that way and for that reason, and who causes the absolute tragedy that has befallen Eric Richens' sons and family. A person convicted of those things is simply too dangerous to ever be free. Accordingly, Ms. Richens, based on your conviction on count 1, first-degree felony aggravated murder, the court hereby sentences you to life without parole. You have the right to an appeal. You must file a notice of appeal within 30 days. You have the right to be represented by counsel on appeal. Mr. Bloodworth, anything further?
No, Your Honor.
Ms. Lewis, Ms. Nestor.
Your Honor, we anticipate filing a motion for a new trial and would like a date set. We have a substantial record in this case. We will file a notice of appeal of the conviction and the sentence and ask that everything be stayed pending the motion for a new trial as we're entitled to do under Rule 4B. Excuse me, but we think we need sufficient time to file a motion for a new trial based on the substantial record that exists in this case, longer than the typical 14 days, because this is not only the trial itself, but the years of litigation and motion practice that preceded the trial. We were hoping that we could get an agreed deadline of 90 days to file a motion for new trial, mainly because for half of June I'm out of the country and for half of July Ms. Lewis is out of the country. Normally we would ask for 60, but there's going to be a month in there where both of us aren't available. So we're asking for 90 days.
All right, Mr. Bloodworth.
Your Honor, the state objects. The rule provides for 14 days. You can't imagine this is a decision that was made today, I think. Council's had the last 53 days to prepare the motion, 14 days pursuant to the rule. I appreciate that it's a lengthy record in this case, but the issues available for the trial are fairly narrow. The state recommends the 14-day time period as provided by the law.
There is one other thing, Your Honor, on that as to why we need the extra time. So we have asked the county to retain an expert to assist to do a declaration attached to our motion for new trial. And it's going to require us to go before a separate entity to decide whether that funding is approved, and that just takes time. So that's another issue we need.
I feel like there's more that I need to know in order to make this decision. And so I can also appreciate why defendant is concerned about the 14-day deadline so they do not lose that opportunity. Sitting here today with very little information and the state having very little opportunity to respond to this idea, I'll extend your deadline to 28 days. But within that time, if you want to file a motion to extend it, Ms. Nestor, with more detail, you have 14 days to file that motion.
Not a kind of clarification. So the court
14 days from now, they have an opportunity. They have a deadline to file a motion to extend the 28-day deadline. If they don't, it's 28 days.
Gotcha.
I acknowledge that that 28-day deadline may cause practical difficulties for the state's team, and if I need to extend the state's response deadline, I will certainly give that fair consideration.
Understood.
Ms. Nestor, Ms. Lewis, anything else today? Ms. Richens, you are hereby committed to the Utah State Prison and remanded to the custody of the Department of Corrections. This court is in recess. Please follow the deputy's instructions. We're off the record.
The courtroom went completely silent as the judge delivered the final decision in the Corey Richens murder case. Convicted of poisoning her husband, Eric Richens, Corey listened as the court revealed the chilling detail that shocked everyone most. After allegedly failing in her first murder attempt, she spent the next 17 days planning another one before finally succeeding. The judge described the motive in one brutal word: money. But the most emotional part centered around the couple's 3 sons. The court admitted struggling with whether those boys would someday resent a life without parole sentence or fear the possibility of their mother ever walking free again. In the end, the judge concluded that anyone capable of murdering the father of her own children for financial gain was too dangerous to ever be free. Seconds later, Corey Richens was sentenced to life without parole.